Deacons. I'm in our Phoenix office, but really for 22 years was in New York. That's my primary home base, I would say. But I've handled OSHA matters across the country in 30 plus states. And I really feel privileged to talk to you today about some lessons learned and things you can do if OSHA shows up. Now, the beauty is, even if OSHA never shows up, a lot of these items are still 100% consistent with an effective health and safety program. So if you think we're good, OSHA's never showing up, you really still should know these items. And even if it's not OSHA, even if it were to be, say, have a personal injury action, some of these items sort of carry over. So I want to talk quickly, and I kind of jumped ahead on a couple of screens, accident investigations. Now, it's really important as a safety professional when you're doing an accident report, there's been an incident. Um, there's sort of two purposes, unfortunately. There's the true and pure safety purpose, which is to prevent this from ever happening again, doing a root cause analysis, dissecting it, backwards, forward, sideways. But then at the same time, some of those findings could be used against you in the OSHA matter. Okay. I have an OSHA case going to trial next week, actually, on Wednesday. And the post incident accident report is marked as an exhibit in that case. So if you're unduly critical of yourself in your incident report, that could be harmful. And unfortunately, that did not happen in our case. But just one attorney tip, if you're doing an incident investigation, whether it's related to an OSHA incident or not, meaning OSHA's inspecting or not, sometimes you can do an initial incident report and keep it rather, just the facts. And then if you're doing a later root cause analysis, that's certainly a deeper dive. You might want to have that protected by attorney-client privilege. That is an attorney's perspective, and you would not, I don't think, need to do that for every incident. But if you do have, a worst day scenario with a bad incident, you might have your upfront public facing incident report, and then you have a root cause analysis. Let's jump ahead right into managing OSHA inspections. So I think personally, I've handled hundreds of OSHA inspections and then also, negotiating the citations and then obviously all the way up to trial. I have my 10th OSHA trial next week. You really need to know why OSHA shows up. Usually, whether it's a federal OSHA state or state plan state, OSHA will tell you why they are showing up and why they are there. They won't give you advance notice, of course, but you need to know why the inspector's there. So that dictates what OSHA is allowed to do. Just as OSHA wants you to follow the law, OSHA needs to follow the law as well. And that means inspectors can't just go any place. They need some authority and grounds to do so. So the takeaway on this slide, when OSHA shows up, the three big things. Was it because of an injury? If it is, the inspection really should be limited to matters relating to that injury. Is OSHA showing up because of an anonymous complaint? That's something else. If that's the case, OSHA should limit the inspection to the items in that anonymous complaint. And also, with an anonymous complaint, you can get a copy. I mean, we've said, well, before we consent to an inspection, we want to see the written complaint because I know, inspector, you're telling us the complaint says all these items, but we'd prefer to see how it looks on the OSHA intake form just so we're totally clear. And lastly, it could be one or more types of a programmed inspection, either site-specific targeting or national emphasis, regional emphasis, local. So when we tell OSHA these things, when inspectors show up, we're always really, without fail, very professional, and we just want it to go orderly and everyone have a clear understanding. That's the long and short of it. So you might think, well, it's easy for Mike to say he's a lawyer and this is all he does. 100% of my practice is OSHA, but we still do it diplomatically, just like you would do it diplomatically. I mean, these are your rights, and you're entitled to, enforce them. So, really quickly, when OSHA shows up, you're not going to have any prior notice. You might think OSHA will show up. Let's just say you have a injury and EMS is there. Likely OSHA is getting called, so you should know OSHA will be showing up. Okay. Uh, Another important concept, and I know this is almost like issue spotting. I'm just throwing out issues. So in the future, if OSHA shows up, these issues might bubble up to the surface, and you think, wait a minute, doesn't the Fourth Amendment apply? So the Fourth Amendment protects you from unreasonable searches and seizures. As an employer, in your place of business or even on some job site, the Fourth Amendment to the US Constitution applies, and that protects you from unreasonable searches and seizures. So, what that means, basically, boiling it down, is OSHA needs your consent to do an inspection, or OSHA needs a warrant. Now, I actually recognize some of the names here on this presentation, as attendees, and I know you're sitting thinking, yes, of course, but many people actually don't know that. So when OSHA shows up, let's say it's New York, the inspector invariably won't have a warrant. When the inspector says, okay, ready to go, and you're like, sure, let's get going. Where do you want to look at first? You don't know it. You might know the US Constitution, but you don't know that under the Fourth Amendment to the US Constitution, you just consented for OSHA to start the inspection. That's a very, I don't want to say scary, but um, it's called implied consent. In other words, you consented to this inspection because you never objected. So it's kind of hard. Someone from OSHA shows up, they're a governmental, worker, they have authority to cite you. Your relationship with OSHA is ultra important. And then you're supposed to know that you can say no. And we don't tell clients often. I mean, once in a blue moon, there could be a reason not to consent to an inspection. But again, this is all you want to cooperate with OSHA. Listen, we obviously know the rules very, very well. We can raise your rights to whatever level or degree you want, and sometimes we do. But usually with the Fourth Amendment, we raise the issue proactively and say, look, we know you need a warrant, you don't have one, so you need our consent. We're inclined to consent to the inspection, but before we do, we just want to make sure there's a clear understanding of the scope of the inspection, what you intend to do, really where you plan to go. That's a big thing, but also what interviews you might like. So these are the things proactively you get talking about it, and that prevents surprises. Let's say you're a safety professional, you go to 10 different Know Your OSHA defense rights presentations, and then OSHA shows up. You're going to be thinking these things. And then you're going to think, how do I start like getting this into the dialogue? Well, you have to say it. You have to say, I know you need consent, or that I know the Fourth Amendment applies. And you just say it again nicely. You're not there to say, where's your warrant? I mean, that's not going to help anyone. So you need to talk diplomatically and just say, look, again, this is all about having a good and orderly inspection. So that's a Fourth Amendment. I would say use that to your advantage because, again, you can limit the scope, you can get a clear understanding. As a lawyer, one thing I've learned over 25 years, sometimes the hard way, you always want to prevent surprises. So deal with things up front. Um, so someone just wrote, does Ogletree write procedures for companies on what to do when OSHA comes to the door? I've written basically this entire presentation into 4 pages. with exactly what your rights are during each stage and reference to the field operations manual, or I think it's 1903 something or other. So anyone emails me, I mean, no questions asked, I'll flip this right to you, or even maybe Cindy can share it. Okay, having an OSHA response plan is just a great idea. Let's leave it at that. If you don't have anything written, you might want to put something in writing for the, and yes, I'll share the presentation. Anyone who asks. So you should have an OSHA response plan. Um, and you should really designate one person to be sort of the know-it-all. I mean, it would be great if everyone in your organization understood the OSHA inspection process. Again, very, very well. But it is a really good idea to have at least one person who people go to ask, and that person feels, look, this is my domain. I really get this. Now, of course, if that person's out sick, right, or out on PTO or something the day OSHA shows up, it's not ideal, but anyway. So here are the 5 stages. I'm going to try to spend about 1 or 2 minutes on each of these, and then I will say goodbye so you can keep learning with others. But 5 stages, opening conference, that's when the inspector shows up. If you get, by the way, a letter from OSHA saying we may inspect you, but if you give us this information, we may not. And it's called a rapid response investigation. In one sense, if your only concern was regulatory exposure, if you get one of those letters, you should be happy because as long as you give a fair response to OSHA, they're not going to inspect you. You're going to write to them and basically just say address any hazard or incident. But OSHA has to show up, right? An inspector has to show up. There's got to be an opening conference. So if you're actually getting inspected, an inspector actually has to show up. If you get a letter emailed to you saying, give us this information and maybe we'll inspect you, maybe not, again, just from a regulatory exposure standpoint, you're probably in the driver's seat. So the walk around. Beautifully, OSHA described this step exactly what it is. The inspector walks around and gets facts and looks for violations. Then document requests and interviews. That can happen literally any time within the 6 months OSHA has to issue a citation. Um, the only item for document requests you really need to be concerned about is if the inspector asks for your 300 logs under the record keeping part 1904. Any request for any record keeping documents, technically you have to respond within 4 hours. We like to think if OSHA insists, but sometimes they'll write and say, we want this by this time. We had a case recently where we thought our client didn't comply with the 4 hours, but OSHA had said, we want this by this time. And they gave a time like 3:30, and at 3:30 that was like 3.5 hours. So in other words, we said, OSHA, I was getting ready to argue, OSHA, you waive the 4 hour requirement because you asked for them within 3 hours and 30 minutes, which is different, so you kind of just waived it. That was going to be a creative argument if our client hadn't given the 300 logs, but they actually had, so we were good. um, let's see, interviews. So let me synthesize this because this is easy to remember. Document request, just ask OSHA to put it in writing. And the only thing really you should give on the spot, I would say, is these 300 logs. Even if you have documents ready, you can say, look, it's our document management policy that we don't give these records immediately. You want someone to look at them and before you give them. That's fair. Again, OSHA has 6 months. You're not delaying anything. And then interviews. For your management interviews, that's right, managers OSHA will want to speak with. We like to say, let's not do that the first day OSHA shows up because you don't have time to prepare your managers. They can't review all the records, they can't get familiar with what questions they might get. You know, a lot of things going successful during an inspection revolves around number one, you understanding the process, which largely means why OSHA is asking for these things. And then just being comfortable with it. If you understand the process, you're going to be comfortable. You're not going to second guess yourself. Your confidence and comfort level go a long, long way.
Hey, Michael, I'm sorry to have to cut you short. We are 5 minutes past the time.
Okay.
I know we had a slow
No problem.
start, but, yeah, if you're willing to share your slides, we can go ahead and get those forwarded out to the attendees.
Okay.
I know that there was a couple of people that were asking about them, so, thank you
Yeah.
so much for, sharing all of your valuable insight with us. Um so let's see. Sorry, I'm a little off. Yeah, I guess definitely being prepared is certainly one way to avoid some extra hours, putting out some unnecessary fires and staying on OSHA's good side, which we all should be doing, even if OSHA wasn't there to support us, right? Of course. Um, so Mike is in our Ask an OSHA Defense Attorney Questions discussion room for an hour from noon to 1 today. He's sharing the Vermont OSHA space, so they're there until 11:30, and then we'll switch the room over for Ogletree. And so make sure to stop by and see him while he's there. If you have any questions or want some additional insight. So next, let's welcome Sam Matthews from Loci. Sam will show